All right, let's take a look at the trustee, keeping in mind that the trustee is the legal owner of property. So when we are evaluating trust assets and looking at title, instead of the property being legally owned by the settlor, it is in the legal name of the trustee. Along with the role of trustee comes various fiduciary and administrative duties. It's important to understand that if the trustee does something wrong, that will result in a breach of his or her or its fiduciary duties, keeping in mind that a trustee may be an individual or an entity like a bank. There are certain duties that cannot be waived. Good faith, following the trustee terms. But in terms of other duties, we need to evaluate the trust terms first to see if the settlor has decided to waive them. If there are express duties, so that the trust terms will prevail, and to the extent they exist, the settlor included them, the trustee must follow them. Certainly a revocable trust, a settlor can change the duties, and verbal changes would be acceptable. So if there is a mandatory distribution of income to the settlor himself, and the settlor says to the trustee, I don't want that mandatory distribution today, the trustee would be following the trust terms by complying with the settlor's request. Other duties that may not be spelled out but are implied in every fiduciary relationship are the duty of care and the duty of loyalty. So the two broad duties of the duty of care and the duty of loyalty, a lot of these sub-duties fall within that. Duty of care, prudent person, keeping in mind a professional like a CPA or a lawyer is held to a higher standard than an individual. Diversification, balancing risks and rewards, those things are duty of care. Duty of loyalty are two main duties that you have to watch out for. The self-dealing, so you cannot, as trustee, do anything, even if it's in the best interest of the trust, for the trustee's own benefit, and there cannot be conflicts of interest. The courts have adopted something called a no further inquiry rule. We're not going to look into why the trustee did the self-dealing or conflict of interest. We don't want to put the beneficiary in the position of having to worry about whether or not this was a good objective thing or not. We have what's called a no further inquiry rule. Some of these implied duties that you'll see, you got to act impartially, can't commingle, you've got to record keep, you got to keep income and expenses separate. The duty of loyalty is a bar exam favorite, can't buy anything from the trust for yourself. Now, of course, the duty of loyalty is not a mandatory duty, so it can be waived. And you've got to look to the trust terms. Most trusts that are drafted do waive this duty of loyalty, allowing the trustee, which quite often could be a family member, to self-deal or to engage in transactions that may be a conflict of interest. But unless waived, no further inquiry. Bar exam favorite. Investment, just like you would invest your own property as a prudent investor. Overall strategy, reasonable care, don't commingle, diversification. You'll see these coming up quite often. Reserve, you got to insure property, act impartially. If you see a trustee favoring one beneficiary over the other without authorization to do so, that would be a breach of the duty of impartiality. You've got to keep your beneficiaries informed and things of that nature. in the event of a breach of fiduciary duty, there are some options. You could ratify it if it's in the best interest of the trust. You could sue for damaging, or you could unwind the transaction. So that if the trustee sold a piece of property to himself or herself because the trust needed cash and selling it to himself, you could save various commissions associated with the sale to a third party. And later on, the property increased tremendously in value. The beneficiaries can come back and say, wait a minute, we want that property back. There is something called an exculpatory provision, so you need to look for that. Make sure that it's strictly construed. Many trustees will not serve without it. Keep in mind, there is personal liability. We've seen that before when the trustee breaches their fiduciary duty. The trustee has to be a bookkeeper, so you have to be familiar and comfortable with income, expenses. It would be fine to hire an accountant to do various tax returns, but allocation of income and principal are the trustee's duty. Also, before we leave this chapter on trust, keeping in mind there are two tools that the courts use when things go wrong. Something called a resulting trust, where a trust was clearly intended, but something happened. Maybe they didn't name a trustee. And a constructive trust is when there is, in fact, a bad act. So those are also tools that courts use to remedy situations. The constructive trust is not a trust at all. It's based on the theory of a trust. And we take the property from the bad actor and force that bad actor to transfer it to the rightful owner.